and Justices of the Supreme Court of Ohio. The Honorable Supreme Court of Ohio is now in open session pursuant to adjournment.
Good morning, ladies and gentlemen. Our first case this morning is 2020-1247, Christina Cruz et al. Versus the English Nanny and Governess School et al. For the appellant, Mr. Patakos.
Good morning. Thank you, Chief Justice. May it please the court. My name is Peter Patakos, and I represent appellants Christina Cruz and Heidi Kaiser. I would like to reserve 3 minutes of time for rebuttal. I would like to begin this morning by emphasizing that there are two things we are not asking this court to do on this appeal. First, we are not asking this court to hold that attorney's fees for post-verdict work must be awarded in every case where a jury finds that a plaintiff should, as part of a punitive damages award, be compensated for their legal fees and expenses. Secondly, despite Appellee's repeated incantation of the term American rule in their briefing, this appeal does not seek to overturn or otherwise change the American rule. To the contrary, we are merely asking this court to affirm a key aspect of an exception to the American rule that is so well established that it could well be considered a part of the American rule itself. Indeed, there is no dispute among the parties or the courts of Ohio that where a jury awards attorney's fees as part of a punitive damages award against a party that is found to have committed malicious, tortious conduct, it is within the sound discretion of the trial court to determine the proper amount of that fee award. And there is no reasonable dispute that under this court's clear precedent, as stated in, for example, the Digital and Analog Design Corp decision, these awards need to be, and this is a quote, adequate both to compensate the plaintiff for his attorney's fees and to fulfill the punitive and deterrent purpose of the exemplary damages awarded. This is a well-established principle of the common law that the legislature has not only left undisturbed for nearly 150 years, but has deliberately taken care to protect, as we see clearly in the damages cap statute, which specifically excludes fees from counting against the cap. And consistent with the twin purpose of fee awards, to compensate plaintiffs and deter and punish defendants, this court has, for good reason, never drawn a distinction between fees incurred before the verdict was obtained and fees incurred in defending that verdict, whether in the trial court or on appeal. Indeed, both the Appellees and the 8th District panel below acknowledge that post-verdict fees are rightly available in other circumstances where trial courts make fee awards, such as in...
Can I interrupt you? How does that work when there is a contingency fee agreement? So if the plaintiff prevails and there's a contingency agreement, the attorneys get a percentage of that amount, correct?
Yes, Your Honor. Yes.
And that's regardless of whether the trial court decides to award attorney fees. And so, and if there is a punitive damage award, then there's a percentage of that also goes to the attorney, correct?
Your Honor, the factor of whether there is a contingency fee is a well-established part of this procedure. That is one of the factors under this court's precedent and under professional conduct rule 1.5 that is analyzed by the court.
But I'm just trying to figure out, so there's a percentage of the compensatory fees, there's a percentage of the punitive damages, compensatory and punitive damages, correct?
Correct.
Okay, so, and the trial court may or may not award attorney's fees.
That is generally within the trial court's discretion.
So if the trial court does award attorney fees, do the attorneys get the attorney's fees plus the percentage of the compensatory and punitive damage awards?
Well, I would say, I think an important point to make here, I think there are several complications in answering that question. I think the first point I want to make here is that the fee award is for the client. It is intended to compensate the plaintiff, to make sure that the plaintiff's recovery is not reduced by whatever amount the plaintiff had to compensate their attorneys. That is the first prong of the important purpose of these awards. And I suppose which portion of any fee award would go to the client would depend on the specific agreement between the plaintiffs. I think there are some agreements that would say the fee award goes entirely to the client. Some fee awards would say it goes to the attorney. And there are many different permutations that could happen in between.
So there's a possibility, depending on the agreement between the attorney and his or her client, that the client could also get a percentage of the attorney's fees. There could be a percentage divvy between the client and the attorney, depending on the agreement, regardless of what amounts are recovered.
Absolutely, Justice Stewart. That is absolutely the fact. And again, I think the more important point is that the fee award is intended to ensure that the plaintiff's recovery is not ultimately reduced. I think another important point to make about this contingency fee factor is that you're analyzing it in the context of Professional Conduct Rule 1.5, which really, Professional Conduct Rule 1.5 is directed at what fee is reasonable for a lawyer to charge the client. This really has nothing to do with the defendant. It has nothing to do with the defendant paying a fee award pursuant to punitive damages. We're talking about what is an attorney allowed to charge a client? And I think it's important to note here that is being the eighth factor. Courts typically find the existence of a contingency fee to justify an upward adjustment to the total fee that the attorney can collect from the client because the attorney took on substantial risk.
No, I get that. Just let me finish the second part of my question. So in this particular case, there were two appeals at the Court of Appeals level, correct? And then this appeal. So
Correct.
In the second, after the first appeal, you went back to the trial court, asked for attorney's fees that included attorney's fees to defend the first appeal, correct?
Correct, Your Honor. And I would add that. Yeah.
Okay, let me finish asking. So then what about the second appeal attorney's fees? And then what about this appeal's attorney's fees? Can you go back to the trial court to ask for both of those? If successful, of course, obviously.
Yes, well, we would say that regardless of what this court rules, this case will get remanded back to the trial court either way for a redetermination of the fees consistent with the other part of the 8th District's order, where the 8th District said that there was a portion of the fee award that the trial court issued in its last order that needs to be reassessed and that more evidence needs to be taken. So yes, this would go back to the trial court. Yes.
And so if you're successful, can you get asked for, if we agree that appellate attorney fees should be calculated, then you could also ask for, at the trial court's discretion, getting the attorney's fees for both the second appeal and this appeal.
Yes, Your Honor, that is our position.
Okay.
And we would ask for those fees. I mean, we've certainly worked very hard at every level of this appeal.
Right. I'm not questioning your work. I was just trying to understand your line of thinking. Thank you. I get it now. Thank you.
Mr. Patakos, Justice Bruner here. Let's say you have a 40% agreement if there's a recovery, and then you're awarded, there's an award of attorney's fees, and that goes to the client. Wouldn't that go to the client entirely as an offset against your 40%? Because you can't split fees with a non-attorney.
I just believe it depends on what would be in the agreement.
But you were mentioning that there'd be a split between the client and your firm, potentially, just if this were a theoretical situation, of the award of attorney's fees, but they belong to the client, correct?
The attorney fee award does belong to the client. That's what the case law says. But you could enter a contingency fee award. You could enter a contingency fee agreement with a client where the amount recovered pursuant to a fee award could potentially be shared with the client and the attorneys.
Okay.
Counsel, Justice Fisher here. What rule do you want us to write? Because sometimes on appeal, even the appellee may win some points, may lose some points, may cross appeal, lose some points. But assuming you still kept your compensatory damages and punitives, doesn't the trial court have to determine how much of those appellate fees should be awarded to the winner at trial?
Yes, Your Honor. And I think it's a two-part question that you ask. I think first, the rule that we're asking the trial court, or that we're asking this court to write, is simply to affirm that a trial court has the same amount of discretion to award fees for post-verdict work in cases where the fee award is made pursuant to a jury's award of punitive damages, as it would in other cases that have been recognized by the 8th District and the sister appellate districts, the 5th and the 9th, as is commonplace in cases where, for example, a fee award is authorized by statute. And to answer the second part of your question, this is a common part of the trial court's process in assessing fees under this court's decision in Bittner and analyzing the Rule 1.5 factors. The question is, what is going to be a reasonable amount to compensate the plaintiffs and deter the misconduct at issue? And no authority of this court has ever drawn a distinction between time reasonably expended on the litigation in the trial court prior to verdict and time reasonably expended in defending that verdict. It's all part of the case. I mean, in some ways, we're only asking this court to affirm that the work that is done in this court and the appellate courts on a case is at least as important as the work done in the trial courts. And we respectfully...
Counsel, let me interrupt you. I'm sorry. Are you asking for the contingency amount out of this pot of money, the punitives, or are you asking for hourly rate and, number of hours to be determined by the court as to the reasonableness?
Yes, Your Honor. Thank you. We are asking the court to hold that it is within the trial court's discretion to apply the lodestar calculation, and that lodestar calculation, of course, covers fees before the verdict and after the verdict, because it's all part of the case. And the holistic approach is the only way to fulfill the twin purposes of these fee awards in the first place. So when we do, if and when we end up back in the trial court, we will be asking the trial court to award fees pursuant to the lodestar calculation.
In addition to the 40% or setting the 40% aside?
The 40% is set aside, Your Honor.
All right. Okay.
Are you asking this rule just for the trial courts? I mean, wouldn't if we were to agree with your proposition here, wouldn't you want it to apply to the appellate courts too, such that you could, on appeal, ask the trial court ask the appellate court for attorney's fees?
Justice Stewart, thank you. That brings up another interesting aspect of this appeal, which is this court's decision in Klein, which gets to the question of where does this end? And the Klein, in Klein, this court emphasized a practical approach. And that was the term that the court used to say that eventually, if you have parties, or it only really takes one party that just simply refuses to settle a matter, this court has recognized that in certain circumstances, even the appellate court would be authorized to make a reasonable determination of fees incurred on whatever the last appeal may be, simply to just put an end to the proceedings. And we believe that, if it comes to that the 8th District would, under Klein, be authorized to say, okay, this is it. This is the limited appeal now. Enough is enough. Under the practical approach set forth in Klein, we're going to determine a fee award of X amount. And at some point, a plaintiff would be happy to just be done. And
the reason why too that I asked that question is because in this case, after the first appeal, it went back to the trial court. It was appealed again. It goes back. It was remanded to the trial court, and that's when you ask for the appellate fees. But I'm curious as to whether the trial court has jurisdiction to award appellate court fees if a case isn't remanded to the trial court. It would say, under this scenario, I see how you could ask the trial court for appellate for post trial fees, but I'm not sure the jurisdictional aspect of ending at for instance, if we hadn't taken this appeal, then if you prevail at the appellate court and it stopped there, could you go back to the trial court to ask for appellate court fees?
I think that the answer to this question kind of shows why Klein allows the flexibility for the appellate court to make a determination of fees. But I believe I would agree that the trial court would not necessarily have jurisdiction to do anything if the case is in the Court of Appeals. The question is whether if the parties don't settle, the plaintiff may file a motion in the appellate court to have the case remanded. I mean, look, practically speaking, 99.99% of these cases will settle. What we're talking about here is the rare case, the extremely rare case where, for whatever reason, a settlement is not reached. And, in those cases, I believe that our courts are well equipped to make these rulings and to make these determinations. This is something that happens all over the country. It happens in cases where fee awards are authorized by statute. It happens in civil rights cases that hold time and time again that these fees, appellate fees, are recoverable, and they must be, or else there are simply grave policy consequences. If you take the cap off, yes.
Counsel, you've used your time.
Thank you, Chief Justice.
Okay. Mr. Bowles.
Good morning. Good morning.
Good morning.
Good morning. May it please the court, I'm Edgar Bowles, representing the Appellees, the English Nanny and Governance Schools, Shayla Roth in Bradford. The appellant here is arguing that this court should fashion some sort of procedural jurisdiction for the award of attorney's fees beyond the trial court into the appellate courts. The decisions, the well-reasoned decisions that are presented to this court and that I've read say that this is a matter of jurisdiction which belongs in front of the legislature. It is not right to come to a court and argue that there should be this some sort of hybrid remedy for awarding fees on appeal and awarding fees, as Justice Stewart has pointed out, where there's a question of how this would even mechanically and procedurally work. It does not work.
Well, Counselor, but let me ask this too. Where is the prohibition of awarding attorney's fees for appellate work?
Well, with all due respect, Your Honor, I look at it the other way and I ask myself, where is the specific authority for the exercise of that jurisdiction? Appellate courts are courts of limited jurisdiction.
Well, but why can't the authority simply be the fact that if punitive damages are awarded, and that's for specific reasons, malice, public policy concerns, etc., we allow the prevailing party to ask for attorney's fees. You can't argue, of course, that an attorney's work at the appellate level is not attorney's fees as part of the litigation. So when you say, where is there a specific allowance, why isn't it inherent in the fact that attorney's fees are allowable when they're punitive, when there's a punitive damage?
My answer to that would be that that the courts have jurisdiction only as authorized by the General Assembly. And that's true of the appellate courts, particularly because they're courts of limited jurisdiction. And that the well-reasoned decisions say that there needs to be a statutory grant for such awards. And the appellant's going beyond that and asking for some sort of procedural remedy to be fashioned by this court that would address fees beyond the trial court. And
But again, where does it say where does it say for trial court litigation? Where is it narrowed to that?
My point is that you need a specific authorization to go further than that, to go further than what the statute says.
But Mr. Bowles, in Klein, it wasn't specific that someone could recover their appellate fees, and we extended it by court decision. So why is that a block to extending the common law?
Klein and other well-reasoned decisions say that where there is a specific statutory authorization for it, that you can proceed that way. But the appellants are not operating within that framework. They're operating within the framework of the common law.
But there was no specific authorization in Klein to award appellate fees. There was a specific statutory authorization.
I submit it's not there. And that's a great impediment.
So are you saying the decision in Klein was wrong?
I do not, but I think that you need to have statutory authorization for this procedural remedy, which the appellant is asking for.
But if we had the authorization, I mean, if you think it wasn't wrong in Klein, where there was a statute for us to say, well, this statute implicitly encompasses appellate fees, why can't we say that for the common law? The statute's just sort of a straw man there.
I believe that's beyond the authorization that comes from the General Assembly.
But Klein dealt with revised code 5321.16, the landlord.
Correct.
There's nothing in that statute that authorizes appellate fees.
Correct.
But they were awarded in Klein.
Correct.
Okay.
I disagree with that on the basis of an application of the law, that without that statutory authorization, I believe it's beyond the authority of a trial court or an appellate court.
So you are saying Klein was wrongly decided?
I'm saying that aspect of its application, yes.
Okay.
And my understanding with Mr. Novak is that I would take only the first 5 minutes and he would take the remaining time. So I refer over to Mr. Novak.
Thank you, Counselor. May it please the court. Your honors, my name is Mark Novak. I also, along with Mr. Bowles, am co-counsel for Appellee's, English Nanny and Governance School et al. I would pick up where Mr. Bowles left off and also to follow up on the question from Justice Brunner. I believe that Klein was correctly decided and that Klein versus Moots is also directly contrary to the position that appellates are taking in this case. I would emphasize that the Klein court repeatedly throughout its decision and the language of the decision made clear that its extension of the award of appellate fees was based entirely on the existence of as Justice Stewart indicated, ORC section 5321.16c. The syllabus of that case stated both trial and appellate courts have authority to determine and tax costs under 5321.16c for attorney's fees occurred at the appellate level. Moreover, in paragraph 13 of that decision, it emphasizes that 5321.16 is a, quote, remedial statute intended to compensate a tenant for a wrongfully withheld deposit at no expense to the tenant. ellipses. Therefore, we hold that a trial court has authority under 5321.16C to tax as costs, excuse me, the attorney's fees incurred at the appellate level. That was the basis, Your Honors, of Klein versus Moots, which I would submit to the court is still good law. And should the court adopt the appellant's position in this case, regardless of what this court does with the American rule, which has been in existence and recognized not only by this court, but by the Supreme Court of the United States, dating back until at least to 1796, adopting the appellant's position in this case would essentially eviscerate Klein versus Moots, because the court in that case, as I indicated, made very clear that the rationale for the decision was based on the existence of the remedial Landlord-Tenant Act statute. Of course, there is no such provision here, no statutory provision at all. I know counsel for appellants alluded to the damages cap statute under Ohio Revised Code Chapter 2315. That statute and 5321.16 are entirely different animals, I would submit. Whereas
let's look at, I think as Mr. Patakis mentioned earlier, the policy implications behind this. So there's an award of compensatory and punitive damages. They may not be very large awards, but awards nonetheless. The trial court awards attorney fees, the defendants appeal, which could essentially wipe out an award, depending on the size of it. And is it fair? Is it appropriate? Is it right for the prevailing plaintiff or plaintiffs in that case to then have to either forego the appeal and maybe settle on some amount that is, extremely low, or let all of the money? I mean, the attorneys can be expected to do it for free, to do the work of defending an appeal for free for the plaintiff. And so doesn't that create an imbalance in positions if the attorneys were allowed to get, and this isn't to say that the attorneys will get attorney fees at the appellate court level. I think what they're asking for is just for the trial court to have discretion, because the trial court might find that the appeal was frivolous and that there was no basis for it, yet and still you're pulling money out of the plaintiff's pocket.
Yes, Your Honor. I thank you for the question, and my response to that would be again, as is well established here, we do have clients that are not going to be out of pocket of attorney's fees here, as has been well established both in the briefs and here at oral arguments. These plaintiffs and now appellants were represented by a contingency fee agreement. They are not to date out of pocket, and they will not be out of pocket.
Well, I won't say out of pocket, but at least a loss, a diminution of their awards.
Correct, Your Honor. And when it comes to public policy aspects of the appellant's position, I would reiterate, I included these, we included these in our Appellee's brief, but I just would like to emphasize for purposes of oral argument that the Ohio courts, as well as the Supreme Court of the United States, has adopted very well-reasoned public policy arguments in favor of the American rule protecting the right of parties. In this case, the public policy aspect would protect appellees from zealously litigating their claims in court. For example, the Supreme Court of the United States in Fleischmann Distilling Corp. Versus Meyer Brewing Company in 1967 stated that litigation is at best uncertain, and one should not be penalized for merely defending or prosecuting a lawsuit. I would submit, Your Honor, that should the appellant's position in this case be adopted going forward, giving it in whatever form or fashion, giving the trial court or appellate court discretion to award appellate fees to litigants that future defendants, not only appellees in this case, would be chilled from challenging potentially unfair punitive damages.
Then that's not necessarily true, because of course the court, if there's a legitimate basis for appeal, then one would suspect that neither the trial court or the appellate court would award those fees. What I think what Mr. Patakis, what the appellants in this case are asking for is the ability to ask for them, to not be barred from seeking them. If there's a legitimate defense, absolutely, even if you lose, then in my opinion, award of attorney fees should not be granted. But if appeal is deemed by the appellate court to be frivolous, quite frankly, why shouldn't the plaintiffs be able to, or the appellants be able to compensate, get compensation for the time that they have spent on an appeal that really had no basis from the beginning? And you have a right to appeal, so it's not like coming to this court where we look at the question and grant leave to appeal or grant authority to appeal. You have an appeal as a right at the intermediate level.
Correct, Your Honor. And to that, I would answer that I don't disagree with your question. My response would be that is not this case. This is not the appellees in this case did not prosecute a frivolous appeal. In fact, we were.
I'm not saying that it is. I'm not making a determination one way or the other whether the court should have granted the attorney's fees. You're saying that they shouldn't even be able to consider a grant of attorney's fees at the appellate level.
Well, correct, Your Honor. And again, I would go back to the rationale in the Fleischman case that the Supreme Court granted, saying that again, when a litigant makes the decision to appeal a case, litigation is an uncertain venture, and the litigant is not going when that litigant makes the decision to appeal, will not be able to see into the future whether the appellate court ultimately decide whether or not the case was frivolous. I would suggest that if the trial court or appellate court, depending on how such a rule would be fashioned, would present so much uncertainty to an appellate that we would see far less appeals, and just granting the trial court and appellate court this power would open up Pandora's box and essentially entirely reorder the appellate field strategy.
Counsel, just go back to Justice Stewart's question. There's no need for a new rule to allow for fees for frivolous appeals, right? I mean, Appellate Rule 23 says that if the Court of Appeals determines that appeal is frivolous, it may require the appellant to pay the cost of the attorney's fees for the appeal, right?
I would agree with that, Your Honor.
So this really has nothing to do with frivolous appeals. This has to do with other types of appeals.
Yes, Your Honor, and I would counter that Appellate Rule 23 makes appellant's argument. I think it makes appellant's argument unnecessary. In other words, Appellate Rule 23 is out there to deter frivolous appeals, whereas allowing a trial court or appellate court to make awards of appellate fees in light of Appellate Rule 23 would be at best redundant, and at worst, again, would have a chilling effect on non-frivolous appeals and discourage litigants from fully pursuing all avenues of appeal in their case.
Novak, if for instance, your party's appealed and they did well in the appeal, it's unlikely that anybody would be talking about attorney's fees, because if you go back to whether it's Ohio or the U.S. Supreme Court, in Ohio under in the U.S. Supreme Court, an exception to the American rule is when the party has acted in bad faith, vexatiously, wantonly, or for oppressive reasons. So essentially, I think probably into. I don't see that it's going to work out the way that you think that it is.
Yes, Your Honor. I think that appellant's position essentially is transposing the punitive damages exception to the American rule with the notion the notion that there has to be, it ignores the fact that there has to be a statutory justification for attorney's fees in the first place. There was no such obviously no such statute. In this case, the underlying case is a common pleas tort case. I cited it. We cited in our Appellee's brief a recent case in the Sixth Circuit Court of Appeals that was, of course, analyzing the case under the law of this honorable court. In terms of the case was Braun versus Ultimate Jet Charters LLC. Now it's an unpublished opinion. We attached that in our brief. The facts in that case were completely on point with this one, in that the plaintiff in that case, successful plaintiff, had pursued a common law tort claim, was awarded punitive damages. The case was subsequently appealed at the federal level to the Sixth Circuit. The Sixth Circuit came back and overturned the award of appellate attorney's fees on the punitive damages claim. Again, relying on this honorable court's precedent that was most recently elucidated in Klein versus Moots, which again comes back to our point that deciding this case in the appellant's favor would essentially turn Klein versus Moots on its head, because of the language in that case was so strongly centered upon the existence of 5321-16C. There simply is no equivalent in this case to 5321-16C that authorized, that legislatively authorized appellate fees in the first place here on.
Thank you, counsel. Thank you. You've used your time.
Thank you.
All right, Mr. Patakis, let me see. You've used your time as well. You may take a minute.
Thank you, Your Honor. I would just like to emphasize that their Rule 23 is well established. This case has nothing to do with Rule 23. It does not impact, Rule 23 does not impact the other contexts where appellate fees are available. And it has nothing to do with the twin purposes of these fee awards as part of punitive damages. They knew this isn't about a frivolous appeal. As this court knows, there is a universe of difference between appeals that are frivolous and appeals that are unmeritorious. And these folks had every chance at every stage of these proceedings to reckon with what the evidence was. I was reviewing the transcript last night and thinking to myself what it must have been like for them to prepare for the punitive damages phase of this trial, which was, of course, bifurcated, knowing that the jury had already held that they were liable for extreme and outrageous conduct that was utterly intolerable in a civilized community. They could have stopped there and made a reasonable settlement offer. They could have stopped with their appeals. I mean, this is not about access to courts. We are talking about an extremely limited subset of cases where the case goes all the way through to a jury. If this court were to accept Appellee's invitation to treat fee awards differently in the context of a punitive damages award, you would see a war of attrition in the appellate courts on every single case where defendants were found responsible for this type of conduct. This would unquestionably. Thank you.
Thank you, Mr. Patakis. Gentlemen, we will take the matter under advisement and you will be notified of our decision.
Thank you.
Thank you. Our second case this morning is 2020-1505, the State of Ohio versus Nigel Brunson. For the appellant, Mr. Baker.
Good morning, Chief Justice O'Connor, and may it please the court, I would like to reserve 5 minutes of time for rebuttal. We are here this morning to discuss the case of the appellant Nigel Brunson, a teenager at the time of the events that brought this case about, currently serving a sentence of life without the possibility of parole. Through the 3 propositions of law argued in this matter, Mr. Brunson is requesting a new trial under propositions of law 3 and 4, and barring that, a new sentencing hearing under proposition of law 1. I would like to first speak to proposition of law 1. Under that proposition, we ask this court to consider that from the very first time a defendant enters the criminal justice system at the time of arrest, and from the first time they're in the courtroom, they are advised that they have a right to remain silent, and that if they choose to remain silent, that silence will not be used against them.
Counsel, I hear you on that. What's our standard of review, though, on that proposition? There was no objection at trial.
There was no objection raised, Your Honor. However, there was a back and forth with trial counsel as to the defendant's silence. However, regardless of that, I believe that the appropriate standard would be abuse of discretion.
So you're saying you don't believe we're under plain error?
Your Honor, I don't believe we're under plain error. However, even under plain error, I believe that this record would support reversal for a new sentencing because the trial court was so clearly explicit in the holding of silence against Mr. Brunson. This proposition of law has its basis in the Fifth Amendment, and we're asking for respect for the Fifth Amendment today. And that's the respect that we believe the precedent submitted in briefing requires. It is important to note that at the outset that Mr. Brunson proceeded through a lengthy criminal trial through which he maintained his innocence, and he continues to maintain his innocence today. Therefore, Mr. Brunson presents a substantially different case than that of a criminal defendant who strikes a plea bargain and then expresses no remorse for the crimes to which he has admitted. The state's arguments...
Mr. Baker,
yes.
we only accepted 3 propositions of law. You mentioned the 4th one.
Well, in briefing, they are numbered 1, 3, and 4, Your Honor.
Okay, thank you.
The state's arguments include that our proposition of law is unenforceable and that a certain degree of negative inferences may be made at the time of sentencing from a defendant's silence, including that the defendant lacks remorse. However, what these arguments do is to reduce the right to remain silent to what is effectively a Hobson's choice. Either speak up, admit your guilt, and pledge that you are remorseful, thus waiving your right to remain silent and negatively impacting your right to appeal, or maintain your silence and have the trial court assume from that silence that you lack remorse, thus using that silence against you. With this Hobson's choice, if you have to say something in order to avoid greater punishment, that statement is effectively coerced. Though the state claims that this is an unenforceable standard, it is not, as this is precisely the case where the standard can be enforced. We know that the trial court...
Counsel,
Yes,
what you're saying is your client had nothing to be remorseful for, so in his mind, because he does not believe, or his position is, I did not do this.
Yes, Your Honor. That is his position. And we know that the trial court used Mr. Brunson's silence against him because the trial court said so. We tell jurors in standard jury instructions that they cannot use silence to impute guilt. Therefore, judges should not be permitted to use silence to punish at the time of sentencing.
Counselor, isn't that the point, though? I mean, historically, the Fifth Amendment was always understood to not allow someone to be compelled to be a factual witness against themselves. has never been understood to preclude use of silence about punishment, right? I mean, this is a new thing that you're suggesting.
Your Honor, we would submit that it's not all that new. I mean, maybe in the grand scheme of history, it is new. However, the case law precedent that we have submitted and the precedential argument that we have made is not new. This is based in U.S. Supreme Court case law.
But the U.S. Supreme Court explicitly decided not to adopt the position that you're advocating, right, Mitchell?
Your Honor, what the Supreme Court decided was that you cannot use a constitutional right in order to effect further punishment. And that is found in North Carolina versus Pierce. And although in Mitchell, they may not have explicitly found our position, they simply left that decision for another day.
And most courts, at least the vast majority of the federal courts since Mitchell have read that opinion to say that the no adverse inference rule in Mitchell does not extend to silence as an indication of lack of remorse, right?
As to adverse inferences, we can say that no Supreme Court precedent permits a trial court.
In the vast majority of circuit courts have read Mitchell differently than you are today, right? They have read that to say that there's nothing that precludes silence and adverse inference of silence as to a lack of remorse.
Yes, but they did so not in the context of a trial. That's the key difference here. Mr. Brunson maintained his innocence, continues to today, and is effectively left with the Hobson's choice that I described earlier. So this is effectively, factually, a very different case than what is presented in those circuit court decisions. Those circuit court.
Counselor, let me ask this. You know or agree under 2929-12D that the court is required to consider whether there has been a show of genuine remorse in determining the likelihood of reoffending, correct?
Yes, Your Honor, we're aware of that.
And would you agree that speaking or not speaking is the only demonstration of remorse or lack of remorse? So in other words, can a defendant show remorse any other way than speaking about it?
Your Honor, there have been cases where factually an individual shot a gun, may have mistakenly shot an individual, maybe not the individual that they intended to shoot, and immediately showed remorse through the act of calling police.
Okay, so there's some other way other than the allocution part of the sentencing. There are other ways.
There are other ways that could come up through the facts of the case.
But Mr. Baker, in your client's case, it was just the opposite based on the testimony.
Your Honor, based upon the testimony, and that is testimony I would like to get to in propositions of law 3 and 4, that's the testimony of Gary Lake. The only evidence at trial was testified to by Gary Lake, and that is the, yes.
Well, so just let me go back a minute. So if the trial court simply said, I find that the offender shows no genuine remorse for the offense and not tied it to his not saying anything, that would have been appropriate.
Your Honor, I'm not sure I follow the question.
So in this case, the trial court specifically made mention of the fact that he didn't say anything. He didn't talk about being remorseful. He said that you was going to stand there in silence, or he actually referred to as silence. If the trial court had simply said, I find the offender has shown no remorse, and didn't tie it to his lack of words, would that have been appropriate?
Your Honor, I believe that we would have been left with no indication in the record that the trial court had in fact used the silence in the courtroom and the silence in the pre-sentence investigation report in order to fashion its sentence. And what I would liken this to is in the law surrounding what a court considers and doesn't consider as evidence in the bench trial context. When we presume that when a trial judge effectively hears evidence that is inappropriate, that they didn't consider inappropriate evidence, they only considered appropriate evidence.
But the trial court has to, under 29, 29, 12, under D5, and I think E5, have to make some determination about remorse. I mean, the statute actually requires it, right?
It requires it, Your Honor. However, we do not believe that that statute is able to give permission to trial courts to violate the Constitution, which is what occurred here.
Fair enough. Thank you.
Counsel, the trial court was fully informed that the defendant's silence was under their advice provided to him throughout the whole post-conviction process of pre-sentence report. Is that correct?
The trial court was told by trial counsel that they advised him to remain silent at the time of the pre-sentence investigation report. However, confusingly, they followed that up by saying that they didn't advise him to remain silent in court that day, which ironically is a violation of Mr. Brunson's attorney-client privilege. The trial court did not show the same concern for Mr. Brunson's attorney-client privilege as it did Mr. Lake's. And that is where, Your Honor, with the court's permission, I would like to turn briefly to propositions of law 3 and 4. The attorney-client privilege should, in this case, given Mr. Lake's withered interest in maintaining that privilege in this peculiar scenario, should be made to give way to the confrontation clause. And Mr. Brunson should have been allowed to fully confront Mr. Lake. And we submit that in the event he had been allowed to confront Mr. Lake, given the importance of Mr. Lake's testimony, given the lack of eyewitness identification of Mr. Brunson in court or any of the defendants in court, that the outcome of the trial may very well have been different.
Counsel, let me ask you about that. How would it be different? I read the transcript, and most of the cross-examination of Mr. Lake really focused on whether he was diminishing his actual role in the case, not really whether Brunson was involved. And why was there not a proffer of the testimony that your client was precluded from using in cross-examination?
Your Honor, I believe that there was a proffer, and given a moment, if I could come back to your question in response, I would truly appreciate it, Your Honor. I believe that I have a more thorough answer for you.
Can you summarize what the cross-examination that was prevented would have elicited?
Your Honor, it is difficult to say because the recording is not in the record. However, what is in the record is extensive argument where the defense refers to the recording as exculpatory and Brady material, and the state, given the opportunity, never argued that it was not exculpatory, never argued that it was not Brady material. And it was specifically given the opportunity to do so at pages 1006 and 1007 of the transcript. The defense had just finished arguing that it was Brady material, that it was exculpatory. The state never described it as anything but that. And Your Honor, I would like to reserve the balance of my time for rebuttal.
Counsel, before you leave, I've got a question for you. The position is that this was a recording that should not have happened. This exchange between Mr. Lake and his counsel, correct?
That is what the record says. That is what his attorney and Mr. Lake maintain.
Okay, so logically, realistically, no attorney would want their client and their conversation to be recorded for the state to listen to. You would agree with that, right?
Oh, absolutely.
Okay, so it's mistakenly recorded. It's identified as such. In essence, then, there, for all intents and purposes, there is no Brady material. There is, because that exchange, for all intents and purposes, never happened.
Your Honor.
I mean, legally, that a conversation is privileged, and you know, you don't set aside that privilege. So I'm wondering how you can call for a breach of that privilege and then label it Brady material.
Your Honor, what I would point out is that we have argued that Mr. Lake did effectively waive his attorney-client privilege in Proposition of Law 3.
But he never spoke about the content, just that there was a recording.
Your Honor, however, once the recording was divulged through discovery and had been divulged to the defendants for months prior to trial, his attorney would have received the exact same discovery because he was a listed co-defendant in this indictment. So what that effectively means is that discovery was out there for months. However, they never lifted a finger to say that recording, hands off, that recording should never have happened. None of the parties should have that. They should have to turn that back over to us and not watch it. There was never any indication in the record that Mr. Lake had any interest in maintaining his privilege. The only argument made
until he did, counsel, until he did. It's not, you can't say there's a privilege and he's got to say it at point A and he can't bring it up at point, M during the sequence of events here. I'm just pointing that out, that to me, that's a problem.
Understood, Your Honor.
If I could follow up on that, it was the state that asserted his privilege, not Mr. Lake.
That is true as well, Justice Donnelly. It was the state who does not have standing, as we've argued in briefing, to assert the privilege, and only then did his trial counsel come into court and testify and argue that the recording, he didn't intend for the recording to happen, despite his own knowledge that recording would happen if he did not speak up. And what's implicitly acknowledged through all of that is that he had this recording and did nothing.
Right. And regarding whether it's Brady material, if the recording was made inadvertent or not, if Mr. Lake had said, "I'm framing your client," that would be considered Brady material, no matter what, whether it was done under privilege or not. Right.
Well, and what the extremity, how extreme the Brady material is not in the record. The only thing that is in the record is that the defense argued that it was Brady material and the state never pushed back against that. So the record only indicates that this is Brady material, and it tends to imply that the state agreed.
All right, thank you.
Thank you.
Okay. I guess, Ms. Porcioni, you're going to go first?
Yes, Your Honor.
Proceed.
Good morning, Madam Chief Justice O'Connor. May it please the court, my name is Tasha Frashoni on behalf of Appellee, the state of Ohio. With the benefit of a full, and I'll be requesting to reserve 5 minutes of argument time for my colleague. So with the benefit of a full record, the state is urging this court to dismiss this appeal as improvidently allowed, or in the alternative to affirm the judgment of the 8th District Court of Appeals, primarily for 4 reasons. First, the parties all agree that only Mr. Lake could waive his attorney-client privilege, and he failed to do so either expressly or through his testimony at a suppression hearing. Second, Brunson's proposed rule on these issues, requiring disclosure of privileged communications for Brady material, would lead to the absurd result of requiring the state to scan all communications for Brady material. Third, it's our position that the trial court did not violate the Fifth Amendment when it noted Brunson's silence and found that he was not remorseful. And finally, even if there were errors in any of these issues, they would be harmless, as Mr. Lake's testimony merely corroborated other overwhelming evidence of guilt, and there were many, many factors noted at sentencing which weighed in favor of a life without parole sentence.
Let me follow up on that, counsel. What if we disagree on whether there was error in the trial court commenting on the defendant's silence? And we find that to be error. And you make the position, you make the argument that, well, even if that is true, there's a host of other factors which would support the ruling that was made. Are you asking this court to just simply ignore that part, take it out, and do our own reweighing and decide whether the court reached the correct decision?
We think that that there are sufficient reasons to justify this sentence. So in other words, Your Honor, we don't think that the trial court punished Mr. Brunson for exercising his right to remain silent. And that's demonstrated by the court noting a whole host of different factors like his prior record, his post-release control, his non-compliance. And what's really relevant in this appeal is that even aside from the silence at the sentencing hearing, the trial court goes out of its way to note that there was, in fact, independent evidence of a lack of remorse. And that's the evidence that Mr. Brunson, directly after committing this crime, was laughing about it and joking how he, quote unquote, had to finish off this victim. And that was particularly telling to this trial court that there was a demonstration of a lack of remorse.
Ms. Forshaw, the evidence of that was the testimony of Lake, correct?
Yes, Your Honor.
So you were saying that essentially that something about the prosecution would have to scan all of its records. I mean, doesn't Brady versus Maryland require the prosecution to turn over all exculpatory evidence to the defendant in a criminal case anyways? So you do have to scan your records, don't you?
I think it's important to note in this case, at least on the issues regarding attorney-client privilege, we're here because of a mistake. In the ordinary course of business, what our office does is we won't listen to jail calls, or we'll stop listening to jail calls if we know someone's talking to their attorney, or if there's a video like there is here where a defendant is speaking privately with their counsel, we won't watch that. And when we hand it over, we would redact it. That didn't happen here. It should have happened. The concern that we have is that if we have an obligation as the state to review all communications, even privileged communications for Brady material, then we go and we then have the obligation to listen to all privileged communications, jail calls, reading letters, listening to all these videos. And that, I think Mr. Brunson would agree, is not something that would benefit defendants down the line, and is not something that they probably want the state to do. With that being said, I will move to the attorney-client privilege issue first. At the outset, I want to note that that the state did not agree this was Brady material, and this court has the record of the hearing that was held here. The state, I think the words from the assistant prosecuting attorney were, quote unquote, we completely disagree that this was Brady material. The problem in this case...
we don't have the recording. I mean, it's not in the record. So
right, so that's...
know?
And that's what I was getting into, Your Honor, is the problem in this case is that the recording is not in the record, and which may be understandable, but there should have been a proffer. They should have talked about the questions that they would have asked Mr. Lake had they had the opportunity to do so. So it's difficult, if not impossible, for this court to say that a jury would view Mr. Lake differently had he been asked these certain questions, because we don't know what those questions would have been. And of course, that was Mr. Brunson bringing this issue, his burden to perfect this issue for appeal and then to preserve the record on appeal. And that simply hasn't been done. Beyond that, on some of the other legal issues.
Counsel, before you move on, what do you make of the argument or the observation that it was the state that exerted the privilege and not to the defendant? In fact, that I guess until the state recognized it or voiced it, and then counsel for the defendant adopted, the state's position here. How does that play out, if at all?
We agree with the trial court's finding that the state's inadvertent disclosure cannot act as a waiver of Mr. Lake's privilege. And I think all of the parties agree that it's not the state's privilege, it's not Mr. Brunson's privilege or any of the other co-defendants, it's only Mr. Lake's privilege, and therefore he is the only one who could waive it. So we can't waive that privilege for him, and because of that, our inadvertent disclosure isn't a waiver. When you look at the record here.
Counsel, let's go back a little bit to what your opposing colleague said. Why didn't Lake's counsel raise it for months? The privilege issue. Is that not a waiver?
Well, that would be factually, he notes on the record that he made a mistake, that this wasn't made aware to him, Mr. Lake's counsel, until this all came to a head at the hearings. And at that point, he recognized that the recording should have been turned off and that he should have asserted the privilege. He does at this point assert the privilege.
But on what basis?
I forget where I was going.
But on what basis does the state exert the privilege for him? Because the state only represents the people, not a witness, not the victim, not the victim's family. So how can the state exert that privilege for him?
We can't, Your Honor. We can't waive it, and we can bring it to the attention of the court, but that privilege, whether we raise it or whether the trial court raises it, that privilege remains intact until Mr. Lake waives it. It's not so, in other words, Brunson's rule is asking for an implicit waiver. So, for example, he's saying you have to take affirmative steps to protect your privilege or it's going to go away. And that's just not the law. That's not what the statute says. That's not what the case law says. We would argue that silence isn't contemplated by the Ohio Revised Code or at common law, so it shouldn't be recognized as an implicit waiver, or what would happen after this opinion if the court adopts his rule, a judicially created waiver. Moving on to the Sixth Amendment issue, just quickly want to note two other concerns we have here. We think the Seventh Circuit case cited by both parties, Raynone, is the most instructive here, and they note two important policy considerations. One, when you allow the breach of the privilege information, one, you do that at the expense of the witness's Sixth Amendment right to effective assistance of counsel, because that witness won't feel free to communicate with their attorney about all manner of different things. And the second issue being that witness will then, knowing that if he cooperates, everything he says will be given to the co-defendants, that witness will be less likely to cooperate, making it harder to prosecute complex conspiracies. So we don't think that this is a zero-sum game where Mr. Brunson's Sixth Amendment right should trump Mr. Lake's Sixth Amendment right. And now that what I would like to do is yield the rest of my time to my colleague so that he can discuss the remorse and silence issue if there are no other further questions. Thank you.
Chief Justice O'Connor, and may it please the court, several points going to the first proposition, the first going towards whether to decide the first proposition, and the remaining going to the merits. So before turning to the merits, I do think we should pause quickly to consider whether silence actually even mattered here. That's true whether it's viewed through the lens of plain error, harmless error, or just this court's discretion to dismiss a proposition as improvidently allowed. I would stress that if you read the sentencing transcript as a whole, I understand there was commentary on silence on the select pages we're looking at. But as a whole, I think the transcript leaves no doubt that the outcome wasn't affected here. I would particularly point the court to pages 3281 through 83 of the transcript. And that's because before the trial judge made any comment on silence, it had already very definitively concluded that this was a cold, angry individual, and that was based on a multitude of factors, including how Mr. Brunson conducted himself during the trial process.
Is this your argument for dismissing the case or for saying it was harmless?
I think it's both, Your Honor. I think they involve the same types of inquiry and I think it can be both even with harmless error, because generally we practice constitutional avoidance. So if it's an obvious harmless error, there's perhaps no need to reach a difficult question that with or without this case, I think we might get an answer from the U.S. Supreme Court on.
But counsel, what about, so if we don't speak about it, what happens in the instance where the defendant is indeed innocent of the offense? And I understand that Mr. Brunson in this case maintains his innocence. But in the case where the defendant is innocent, we get back to, as Mr. Baker was saying, the Hobson's choice. Does the defendant get up and show remorse for having committed a crime he didn't commit?
A couple of points, Your Honor. First, if we have someone who is actually innocent, then the problem is not at the sentencing phase, it's at the guilt phase. And we certainly hope that our appellate process, our post-conviction relief process, and other things are going to solve that. But with regard to the Hobson's choice point, that assumes the answer to the merits question, that the right to self-incrimination, privilege of self-incrimination does extend this far. So I'll move to the merits. And I think regardless of whether you view that merits question as a matter of the text and history or as a matter of existing Fifth Amendment precedent, Brunson loses. Brunson doesn't really engage with us on the text and history. I'll rest on the briefing there, absent questions, and just jump to the presumption that what we're trying to do here is predict the outcome based on existing precedent. And I say predict because, as Justice DeWine, recognized in one of his questions, Mitchell does very clearly reserve this issue. It's page 330. And so we know we don't have a satisfactory answer from the court. But if what we're trying to do is predict, I think the common thread that holds together cases like Estelle, Mitchell, Griffin, Carter is this concern that without an adverse inference rule, we're going to be somehow shifting or softening the burden of proof on the government. And the reason why that concern traveled into sentencing in cases like Estelle and Mitchell is because you had very unusual, atypical sentencing situations. Estelle was a death penalty case where the government bore the burden of proof for aggravating factors. Mitchell was an odd case where the issue of the quantity of drugs had been reserved for essentially a bench trial during sentencing. So in both instances, the government had the burden of proof to show that, to make the offender eligible for a particular sentence. Ohio's system is very different, and I think this goes to one of Justice Stewart's earlier questions. It does require the trial court to consider remorse, but it doesn't put a burden on any other party. Remorse is one factor that goes into an overall sentencing hopper. And I do think that if you rule for Brunson here, you're going to be removing one of the most effective tools for gauging remorse, which is what a defendant does or does not say. At very least, in a case like this, where there's powerful evidence of a lack of remorse independent from silence, I think commentary on silence merely reflects that Brunson had not overcome the already existing evidence in the record. Maybe we have a different situation where none of that's available. But I mean, the other point,
but as I asked Mr. Baker earlier, is there any other way to demonstrate remorse or lack of remorse other than what you articulate or don't articulate?
Certainly, there's other ways to demonstrate lack of remorse. We think that happened in this case. trial court on page 3283 noted the way Mr. Brunson had carried himself during trial proceedings. There was also, as the state mentioned, the comment about finishing off another human being. In terms of expressing remorse, yeah, I think often the best way to do that will be to speak. And I would actually note that the federal sentencing guidelines place a very explicit burden on defendants to either accept responsibility or not. And there's a 2-point downward adjustment that rides on that inquiry. So if you were to rule.
Counsel, what do you, how would you expect someone who is maintaining their innocence to be able to meet this, these 2-point downward, conversion for sentencing, etc., if they don't admit guilt? How do you apply all the things that you had just said?
Couple points, Your Honor. First, I mean, obviously our frontline position is that the right doesn't extend this far. So whether or not they are going to be able to, I think often it will be the only way for them to prove acceptance of responsibility. But again, if the problem is really actual innocence, then our hope with the way our system's set up is that other aspects of the system are going to capture that. I do want to note with regard to the innocence distinction that Brunson is trying to draw, Mitchell actually forecloses any distinction there because it says that even a guilty plea does not waive whatever privilege makes it into sentencing. So there is no basis for distinguishing between those who maintain their innocence and those who plead guilty. So counsel, at sentencing, you would expect Mr. Brunson to say, I am so sorry that I killed this victim, and yet I'm maintaining my innocence. No, not necessarily, Your Honor. What I'm saying is he's not compelled to. The mere fact that he faces a pro-con calculus at sentencing does not amount to compulsion under the Fifth Amendment. I would note, I do think that for someone who does want to express remorse at sentencing, I think Brunson's overstating any negative appellate consequences. Things like harmless error and plain error focus on the outcome at trial. And I think Ohio courts are savvy enough to distinguish, even if something gets said at sentencing, to recognize that those inquiries are focused on trial and that an offender does have the right to be proven guilty through a fair trial process.
Thank you.
Oh, I'm sorry, go ahead.
How old was Brunson at the time of trial?
He was 19, Your Honor. I don't think he's preserved any issue regarding his age. I know he mentions it a couple times in briefing, but I don't think there's no independent Eighth Amendment claim or something like that.
Thank you.
Counsel, if Brunson was advised by counsel to express some type of remorse in hopes of getting a lesser consequences, and then later at a post-conviction process tried to assert some type of actual innocence claim, wouldn't you be inclined to use that testimony of his remorse against them and say he waived any type of actual innocence claim?
No, 2 points, Your Honor. First, in terms of waiver, I don't think there'd be any type of judicial estoppel argument because judicial estoppel only applies when it's an unequivocal position. And I don't think you'd describe it that way for someone who maintained their innocence in trial and was proven guilty. In terms of whether the evidence would come in, I'm not positive on the answer to that question, but this court could always craft a rule down the line if it finds that such evidence would be improper.
All right, thank you. Thank you. Mr. Baker.
Thank you, Your Honor.
Mr. Baker, you've used your time. I'll give you 2 minutes.
I appreciate that, Your Honor. Thank you. First, the state argued at one point that there should have been a proffer of evidence into the record. However, Evidence Rule 103A2 says that no proffer is needed when the evidence is excluded on cross-examination, which is what occurred here. Second, I agree that the state should not be listening to privileged recordings. However, it is evident that not only did they listen to a privileged recording in this instance, they turned it over to everyone in the room. The only people in the room that didn't get to hear it was the jury. And the state has an obligation to turn over Brady material, and they did that here. What their internal policies are, I don't know. I'm not privy to those internal policies. I know what they represent that they are. However, I also want to point out that at one point the state argued, perhaps misspeaking, perhaps not, that Mr. Brunson's Sixth Amendment right should not be allowed to trump Mr. Lake's Sixth Amendment right. However, Mr. Lake's Sixth Amendment right was waived. He pled guilty in January of 2018. This trial didn't happen until June of 2018. So he had already pleaded guilty to a felony 2 robbery, and he was not sentenced until approximately 2 months after this trial, or 3 months after this trial occurred, when he was released from jail that day. And I would submit.
Counsel, how is that a waiver? Counsel, how is that a waiver of the material at issue?
Your Honor, in every plea colloquy, there is a waiver of the right to remain silent. And we would submit that through his plea colloquy, he did waive his right to remain silent, and through voluntarily testifying, he waived his right to remain silent. Or not his right to remain silent, however, his right, his privilege against self-incrimination, rather. I misspoke there.
So you're saying that he waived his attorney-client privilege at sentencing?
No, Your Honor. We're saying that there was a waiver through complete inaction in this case. That being divulged the recording of your conversation by police and then doing nothing is a waiver of the attorney-client privilege. That has been our argument.
Okay.
I wanted to throw one last point, that there is another way to demonstrate remorse in the record without speaking up at sentencing, and that would have been if Mr. Lake's testimony had been the opposite of what he testified to. That Mr. Brunson said, gee, I didn't mean to shoot her and I feel terrible about it, as opposed to what Mr. Lake claimed, which is that Mr. Brunson said that he was bragging about finishing her off. And that, again, is the testimony that Mr. Brunson was not allowed to fully confront. That is the only basis. So that is another way that, hypothetically, remorse could be demonstrated if it were to come about just in the facts of the case through testimony. We asked for a new trial, and we asked that for a new sentencing barring a new trial. Thank you very much.
Thank you. Thank you. We'll take the matter under advisement. You'll be notified of our decision. Marshall, we call a brief recess.
The court will now adjourn for a short recess.
We are here on case 2021-578. NASCAR Holdings Incorporated et al. Versus Jeremy A. McLean, Tax Commissioner of Ohio et al. For the appellant, Mr. Hayden.
Chief Justice O'Connor, and may it please the court. Good morning. My name is Jeremy Hayden, and I am counsel representing the appellant NASCAR Holdings. I would like to reserve 4 minutes for rebuttal. There are 5 principal errors by the BTA in this case, but I would like to highlight 2 of the errors in particular. First, for the vast majority of receipts at issue in the case, the so-called broadcast receipts, the BTA permitted the commissioner to change his final determination and the statute he relied upon in direct contravention of the statutes meant to protect taxpayers from such last-minute changes at the appellate level. Second, the BTA allowed the commissioner to tax NASCAR's receipts just because an Ohio consumer can walk into their local Walmart, Target, or retailer and purchase NASCAR-themed products from a shelf, or turn on their TV or mobile device in Ohio and watch NASCAR races. In fact, much of this case rehashes many of the same arguments the commissioner made in Defender, particularly that but for the Ohio consumer, there would not be a market. This statement, while factually correct, is irrelevant for purposes of the citing statute issue. The commissioner is attempting to once again ignore the plain meaning of Ohio statutes and apply the Ohio CAT in a way that is not only unfounded in statute, but is also unconstitutional and frankly unworkable from a practical point of view. The commissioner would have you look past NASCAR's licensing arrangements and instead tax NASCAR as if NASCAR brought the products into Ohio. But these products and broadcasts are brought into Ohio by others, like the cable broadcast companies that Fox contracts with, not NASCAR. Instead, in nearly all cases, NASCAR charges an annual flat fee for the licenses to its intellectual property for the duration of the licensing contracts, which are long-term in nature. All of the licensing parties are located outside of Ohio, and the contracts themselves are executed and performed outside of Ohio. Further, none of NASCAR's receipts are based on the right to use NASCAR's intellectual property in Ohio. As we will discuss, the statutory phrase based on is pivotal in this case, and it takes on the same importance as where the benefit is received in Defender. In Defender, it was important to look at how Defender's customer, ADT, benefited and not how the ADT's end user benefited. Here in NASCAR, it's important to determine what NASCAR's payments were based on from its licensing activities, not the fact that NASCAR has fans in Ohio. No one disputes that. There are 5 principal errors the BTA made in this case that were referenced in our merit brief. Error 1, the BTA erred by permitting the commissioner to change the legal basis for his final determination for the so-called broadcast receipts. For the vast majority of receipts at issue, approximately 70%, the commissioner originally held his final determination that NASCAR was a broadcaster, and hence the term broadcast receipts, and that NASCAR's receipts should be cited according to Division I rather than Division F of Revised Code 5751.033. In fact, the commissioner held in his final determination that administrative regulation for broadcasting services applied. Everyone now agrees that NASCAR is not a broadcaster, it doesn't have its own network or channel, and it's not providing services. The commissioner's auditor even held this position as late as depositions taken at the BTA level, claiming NASCAR was a broadcaster. And when he was asked to explain why, he said he didn't know, but I quote, "Well, I know that on any given Sunday when NASCAR races are being held, no matter where they're at, I can turn on my television in Ohio and watch a race." That's in our supplement at page 29 in the record. The commissioner eventually admitted his error at the BTA. The BTA then affirmed the error. By doing so, it made at least 3 reversible errors. First, this court's precedent Defender holds that determining the correct statute is important, particularly between Division I and F under 5751.033. The commissioner and the BTA would have you conclude it doesn't matter what statute applies, but then ironically, they say the Defender does not apply to this case at all. This logic does not hold water. If Defender applies, it's clear that NASCAR's licensees did not benefit in Ohio, as they are all headquartered outside of Ohio, as was ADT. Second, the commissioner is expressly prohibited from changing this determination by 570305H. If the commissioner could do this, think of the absurdities. Could the commissioner change a CAT assessment to a sales tax assessment at the BTA? Obviously, the answer should be no, and it should be no in this case. Third, the BTA can't do what the commissioner couldn't do himself. The BTA's own precedent, CARSTAR, recognizes that 570305H precludes the commissioner from revising and changing the underlying assessment while the matter is pending before the board. You may ask yourself, why did the commissioner not just dismiss this case and issue a new assessment? Well, the reason is there was a 10-year statute of limitations, and the audit period in this case dates back to 2005 through 2010. So the commissioner couldn't do that. So the BTA allowed the commissioner to do what he shouldn't have been able to do. The second error is that the plain language of Division F prohibited citing NASCAR's intellectual property receipts to Ohio. The relevant part of subsection F, when there's a right to use in Ohio, is that it's taxable to the extent the receipts are based on the right to use the property in Ohio.
Let me ask, let's get to the substance, maybe. Let me ask you about that. So, someone gets a license from NASCAR to make bobbleheads, say. They make a Kyle Busch bobblehead in North Carolina. They sell it in Ohio. As I understand the statute, it says to the extent that the receipts are based on where the property is used, that then it's cited to Ohio. So where is, in that case, where is the intellectual property used? Is it used in North Carolina when someone uses the license from NASCAR to manufacture the bobblehead, or is it used in Ohio when some kid gets a Kyle Busch bobblehead for Christmas and decides to play with it?
Your Honor, we would hold that those receipts, unless they're specifically based on Ohio, would be cited in North Carolina. But the relevant determination is not really the state at hand. It's really inside or outside of Ohio when you're looking at this.
Okay, well,
No.
but stay with me here a second here.
Sure.
So what does it mean for it to be used? I mean, I assume that at least in the licensing standpoint, someone can figure out where property is it used. I mean, again, is it used when it's manufactured, or is it used when actually someone has a product and plays with it, or whatever, puts it on their mantle?
Yes, Your Honor. I mean, the statute really, I mean, it breaks into two parts, right? The right to use, and it's clear that, and we concede that the licensees have the right to use the property in Ohio. They have the right to use the property in some cases worldwide. It's the second test that really gets at, are the receipts based on the right to use in Ohio? And in that case,
if you're paying someone royalties based on the amount of sales, I presume you can figure out how many sales there are in what state. And if it's just a flat royalty based on the amount of sales, then it would seem that you could do that to Ohio.
The problem with that, Your Honor, is that it's not founded in statute. That would be like a look-through rule. And the example I would suggest would be, let's take Fox Broadcasting, for example.
Well, I get the broadcasting one. To me, the state has a much tougher argument there. But I want to stick to the license fees.
Okay, sure.
So we're talking, I guess, property.
Yeah. So what if NASCAR manufactured? Think of NASCAR as a content manufacturer, just by analogy. So if it manufactured its content, it then licensed it to a wholesaler, and that wholesaler then, sold into retailers who then sold to the end consumer. You really have to go up the vertical chain. It's not that we're saying that these products, when they're sold in Ohio, don't get taxed. What's important is who brings those products into Ohio, who actually uses, who actually does that. And that's why the statute, by using this approximation or this audience factor, and I'll stick with the population factor because that's more applicable to the manufacturers here, that's why it becomes unworkable. When this court decided Defender, it looked at Professor Pomp's article on this, and Professor Pomp has a long dissertation of, look, states have tried to do this dating back to the 1980s. But only 2 states legislatures have put in kind of a look through or population or audience factor since 2004. And the reason why is because of these questions that you're getting at. It's so difficult and so unworkable, and it becomes ambiguous. And, at the end of the day, taxing statutes are narrowly construed. If there's ambiguity, it's resolved in the favor of the taxpayer. And so, that really gets down to why inserting words into the statute, as a commissioner would do, and inventing methodologies really becomes difficult. I mean, this is information that was not in NASCAR's possession. It doesn't have this information. The commissioner then complains that NASCAR didn't provide this information when the commissioner could have used the subpoena power to obtain the information, potentially from Fox and BTI and some of these other licensee parties. But it is exactly that question that you're getting at, the root of it, the complexity, and the fact that the statute should end on its plain words and its plain meaning.
Do we need to get to the constitutional question?
Yes. I mean, well, you only need to get to the constitutional question if you disagree with our interpretation of F. So I think the constitutional questions are very valid in this case, because just because something is put on a screen, and you've seen some of our examples of a slippery slope of, if you put something on a screen in the Netherlands or Australia or so forth, and someone makes money off that, and somehow that just ends up on a mobile device in Ohio, and now Ohio wants to tax that. And that's not that absurd of an example. We've got people making millions of dollars off YouTube, sometimes tens of millions of dollars off YouTube. That really is a slippery slope and a dangerous precedent. It becomes a watershed precedent, and it extends beyond any constitutional parameters, either from this court or the United States Supreme Court. You know, in Crutchfield, there were customers that they were shipping products into, right? At the end of the day, customers in Ohio that were getting this. So Crutchfield was directly shipping. And Wayfair, there were either property, payroll, or people. In this case, NASCAR, with respect to these receipts, has no connection with Ohio. The only connection it has are fans, and it has no contractual privity or otherwise. So this really is a reach in terms of on the constitutional side too. But Justice, I agree with you. You don't get there unless F is interpreted differently. And I think on its plain, ordinary meaning, when you look at based on, both this court and the United States Supreme Court has said based on means something's dependent upon something. It serves as a foundation for. And how can NASCAR's receipts form a foundation or be dependent upon it when it receives a fixed fee in many cases, right? A one-time annual fixed fee, and it doesn't make $1 or more. I use the broadcast receipts, but we can go with any of them. You know, I use the broadcast receipts. It doesn't make another $1 if there's another viewer in Ohio, right? At the end of the day.
That's not true of the licensing fees, right? I mean, the more.
Well, just a one contract. That's correct, Justice. So, sorry, I didn't mean to interrupt.
I understand your argument with as far as the broadcasting fees. I mean, it seems pretty clear that there's no, what they get paid is not based on the right to use in Ohio, but the merchandise licensing fee seems more difficult.
Yeah, well, the merchandise, I mean, wasn't based on sales into Ohio. It was sales anywhere. And in that case, the territory was much broader than even the domestic territory. And that's one thing I do want to bring up is that, you know, the commissioner, limited this territory in all cases to the United States. But, you know, if you look at his final determination, it says, how many countries, 150 different countries, it's televised all over the world and shows the market. And NASCAR's just, it's trying to get at the theme that NASCAR's too big to tax, which is the wrong, the wrong sort of analysis, that we just skip over the statutes. But I think it's important to note that, you would have to look through, if you looked at that manufactured product, you'd have to look through several levels. I mean, and that's what this court's rejected in several cases. It's what the commissioner rejected even in its Lexmark brief, that we're not going to look at your customers and so forth. And that becomes a slippery slope. And then we have to differentiate and say, well, it was used where it was sold, even if it was a direct sell by the licensee, which in many cases it's not. And if we're going to say that, that's an ambiguity that I think, goes against the precedent of this court that would be resolved in the favor of the commissioner as opposed to the taxpayer.
Okay, so if the property were specifically bought for use in Ohio, you agree that would be taxable. But if it's a flat fee and it could be used anywhere within the United States, you're saying we shouldn't come up, or you shouldn't come up with a proportion of its use in Ohio that would be taxable. Do I have that right?
Justice, it's mostly there, but not all the way. I mean, I think we have to really look at the statute and narrow down to the words, and that those receipts that the licensee pays NASCAR have to be based on the right to use in Ohio. So you have to look at each circumstance pretty carefully, but in all of these licensing agreements, none of them are based on the right to use in Ohio.
But if it's based on the right to use in the United States and it's used in Ohio, should we be, or you be, looking at what proportion of use actually occurs in Ohio and that be taxable?
No, Your Honor, because that gets into what the commissioner is trying to get us into, which is, I think, is a misdirection, which is a reasonable approximation. And even the limited states that have done that have statutes, they have administrative rules, they've gone through public comment and processes to get there. In this case, those words don't appear in the statute. We'd have to add language to the statute. To the extent that you can't determine where it's used, you'll look at the population. The commissioners had 21 years to adopt administrative rule here. has not adopted administrative rule. And that's assuming that that administrative rule would even be constitutional as applied to NASCAR.
Well, and I'm not saying looking at the population, but I'm saying looking at the use. I mean, does NASCAR have a way that it quantifies how that property, intellectual property, is being used state by state? And if so, should NASCAR be required on that basis to pay taxes?
Well, if that was in the law, then NASCAR would definitely collect those records, but it has no business case to create those records. And what it did is it based off the taxation off the records that it had in its possession. And again, I think the statute would have to give notice to the taxpayer that that's how it was going to tax. Otherwise, we lack certainty. We lack predictability, the type of transparency that we need with taxing statutes. At the end of the day, taxing statutes are a taking. And remember that we're looking with hindsight back to periods that started in 2005. And those words didn't appear in the statute. I mean, I understand the comments. I'm sorry.
Didn't mean to cut you off, but that led to my question about the constitutional question, because if what I was just saying and that you were arguing against were the case, I mean, wouldn't that be an infringement on interstate commerce?
Yes, it would be. Yes, it would be. So I'd like to reserve the rest of my time for rebuttal.
Thank you, Mr. Hayden.
Thank you.
Okay, Mr. Rockenbach.
Chief Justice O'Connor, and may it please the court. I apologize, my camera seems to be acting up a little bit, but before diving into the statutory and constitutional issues presented by this appeal, I'd like to briefly emphasize two principles that drive Ohio's commercial activity tax. The first is that the General Assembly enacted the CAT to remedy some of the inequities of the old tax regime. Whereas under the old tax regime, the General Assembly imposed a high tax on a narrow number of entities, permitting larger, savvier corporations to structure their affairs to evade taxation and to thus shift that tax burden onto smaller corporations. The CAT imposes a small, just 0.26% tax on a wider number of business entities with a baseline presence in Ohio. Second, as this court explained in Ohio Grocers Association, the CAT is not a tax on transactions. It is instead a tax on the privilege of doing business in Ohio that is measured by gross receipts. These principles also drive the Intellectual Property Division, Section 5751.033F, which tells us how to cite as receipts from the sale of intellectual property. The key sentence of that provision says, if the receipts are based on the right to use the property and the payor has the right to use the property in this state, then the receipts from the grant of the right to use such property shall be cited to this state to the extent the receipts are based.
Let me stop you there. I mean, how can you say that the broadcasting rights, for example, are based on the right to use the property in the state? Those rights are the same whether, you know, regardless of how many people watch NASCAR in Ohio.
Right. So the second sentence, Your Honor, only asks whether the right to use, whether the receipts from the right to use the intellectual property in Ohio are based. That's the source of the receipts. It's a different metric than the first sentence. And so if we walk through the text of the provision, the first clue is the word to the extent. That suggests a sliding scale, an estimation of an amount. The second clue is the term based on. As the Supreme Court, the U.S. Supreme Court has repeatedly said, that suggests but for causation. We posit here that that means that you simply ask, but for the inclusion of Ohio in the bundle of territorial rights, what would the receipts have been? This also accords with the structure.
But you don't really have an answer to that question, right? I mean, you have a really wildly rough approximation that is based on the total, what Ohio's population is compared to the rest of the country, regardless of whether more people watch NASCAR in North Carolina or whether there's people who are watching it in Europe or whatever else, right?
So 3 points on that. The first is that we would only have to determine the amount of actual users when the receipts are based on the actual use. That would be the first sentence of Division F. The second answer is, if we think about how this would work out in an easier case, perhaps instead of saying Fox receives the rights to use intellectual property throughout the United States for $150 million, it might have written the contract in a way that says Fox receives the right to use the intellectual property in all of these states listed out and assigned a $5 million value to Ohio. In that case, we would know which receipts the right to use Ohio, the right to use the property in Ohio came from. Our case isn't actually any different under the law, under the statute. The only difference is that we don't have direct information about that value. In that case, the CAT statute, especially here where NASCAR failed to file a return, authorizes the commissioner to use any information within his possession. And this court ultimately reviews the board's determination that that value was correctly estimated for reasonableness. Here, the number of households with cable televisions, 4%, amounts to a reasonable estimation of that value. To hold otherwise would greatly undermine the purpose of the CAT, one of which was to prevent corporations from structuring their affairs in a way that evades taxation. There's no economic difference between the contract that NASCAR has with Fox here and another contract that lists out all 50 states. And so the ultimate difference between those two provisions isn't one as a matter of law under the statute, but is instead one of facts that relies on what the commissioner has in his possession.
So I'm curious. I mean, this may be a little bit of a side point, but does the tax department do other sports and other intellectual property the same way? I mean, with English Premier League, for example, would it have the same kind of calculation for their United States rights?
I'd love to be able to answer that, Your Honor, as the tax commissioner is entirely committed to applying the same rules to everyone. But under Ohio law, the information about other tax returns is confidential unless there's an appeal. So I can't directly answer that, but I can tell you that the commissioner would apply the same approach in all circumstances. Once we know that an entity like NASCAR has gross receipts that pull it under the CAT, we would apply the same approach, seek information from the taxpayer, and then if we don't get that information, use the information in the tax commissioner's possession to make a reasonable estimate in that absence, which is exactly what the statute permits the commissioner to do. Here, the commissioner relied on the households with televisions, which I think is a closer estimate to the number of the watchers in the state than just the general population, and that was entirely reasonable. If I may address—
Well, counsel, before you get there, let's go back to Justice DeWine's bobblehead questions. These bobbleheads are manufactured, I don't know, overseas, Taiwan. They're obviously the manufacturer and then the distributor have an agreement, and then the distributor is not the distributor paying tax on these bobbleheads in Ohio?
So there's a good chance, especially if the distributor has a baseline presence, that they would be paying that tax.
Okay, so they're paying a CAT tax in Ohio based on these bobbleheads, right?
Yes.
And then you want NASCAR to pay a tax based on the same bobbleheads.
Well, that is the result of a choice that the General Assembly made to tax gross receipts as opposed to taxing income. And to compensate for that, the CAT tax is a very small tax, just 0.26%.
Oh, I understand, but you know, that's neither here nor there when we're talking about the application of the statute. Well, what about the manufacturer? You know, it's a entity outside of the United States. Are they subject to CAT tax?
Well, they would first have to meet the baseline presence requirements. Here, NASCAR meets those requirements through the races that it holds in Ohio. So that's one check on that fact. If they do meet the baseline presence requirements, the statute doesn't draw a distinction. We would treat them the same way.
Okay, so potentially Ohio is taxing these bobbleheads from 3 different entities.
Right, it's imposing a small tax on 3 different entities as opposed to maybe a large tax on one entity. And if I may address the argument that the board couldn't affirm the assessment based on the intellectual property division. The statutes 5703.05 clearly give the board broad authority to modify, remand, or affirm assessments, valuations, and determinations. Here, the board acted properly. It affirmed the assessment. It at most implicitly modified the determination, but the statute permits it to do so. They argue that another statute prevents the commissioner from changing the determination pending appeal, but that statute doesn't prevent the board from modifying the determination as part of its final order. And I think this court's case law bears that out. For instance, in Key Services v. Zano, this court said that the board works independently of the commissioner. Its findings are de novo. And in Krenbrink v. Testa, this court applied those principles to affirm a theory of liability that the tax commissioner raised for the first time in the middle of the board's proceedings. As for the statute of limitations argument, that only applies to the making or issuing of an assessment. The statute of limitations statute defines assessment to mean a notice of payment or underpayment. And that notice here was issued on December 24th, 2012, making it timely. Now, what happens to a determination or a reassessment? Those are different words under the statutes, and that doesn't trigger the statute of limitations. There's an analogous provision, RC 5703.60, that says that in response to a petition for reassessment, the commissioner can issue a corrected assessment, and that corrected assessment relates back in time to the original assessment. That's essentially what's happening here. If the court doesn't have any other questions about those statutory provisions, I could briefly address the constitutional issues.
All right, go ahead.
So on the preserved constitutional issues, this court can quickly dispatch those. This court in Crutchfield held that the baseline presence test of 500,000 gross receipts in Ohio satisfies the Commerce Clause, and that's what happened here. For the fairly apportioned, the taxes here were fairly apportioned for all the same reasons that they are reasonable under the statute. It's a fair estimation of the value that that Ohio, the right to use the intellectual property in Ohio, added to the contract. As for the substantial nexus to the transaction arguments, we again assert that they haven't preserved these by raising them in the notice of appeal to the board. But even if they had, this court would have to remand to the board to find facts about the substantial nexus to the activity. For instance, what exactly how NASCAR's activities in Ohio specifically promoted the value of its intellectual property.
Can we go back to your statutory arguments? I'm still struggling with what it means to use NASCAR's intellectual property. So go back to this example about the something that's manufactured wherever it is, Taiwan, North Carolina, and then it's sold in Ohio. When is NASCAR's property used in Ohio?
So in your hypothetical, are the receipts based on the amount of use, the actual use?
I just want to understand used. I want to understand what it means to use intellectual property.
So
if someone clearly, if someone manufactures something using NASCAR's intellectual property, they're using NASCAR's intellectual property, correct?
Yes.
What about when I go buy that for my son? Is it being used then?
Yeah, I think it'd be being used at the point of sale as well.
Okay. What if my son sells it to another kid in his class? Is it being used then?
I think it's being used then, but that doesn't necessarily mean that the upstream owner of the intellectual property would be taxed on each of those transactions. The place, we're ultimately just looking at the relationship between NASCAR and Fox. Has Fox purchased the right to use intellectual property in Ohio?
Well, I'm not on Fox. To me, that's easy. What I'm on is these licensing fees for individual products. Because I'm struggling to just understand how you cite is based on where the receipts being based on the right to use property in the state. Under the statute.
So I'm not sure that the legal challenge to those particular transactions is before the court. I think that and those are
licensing fee transactions. Certainly, you have this theory on the licensing fees that you're entitled to a proportional share based on Ohio's population. So.
And so I believe that those contracts are structured to be keyed off the amount of use in the state, and it's where the
is that where the ultimate end user ends up? I mean, you're approximating something when the tax commissioner says that they are basing it on the proportional share of Ohio's population. So I'm trying to figure out what it is you're approximating.
Right. So the approximation is what portion of the receipts come from the amount of use. And in the absence, so one way that they could determine that is by keeping track of where everything is sold. And keeping track of each of the receipts that come from each individual state. But in the absence of that specific information, it's fair to use population metrics as a rough estimate for that. The Multi-State Tax Commission supports that approach. And at the very least, that approach is fair in a case like this. Where
so anytime something is sold that has NASCAR intellectual property, that's when it's used?
I think that's going to be right, but that doesn't necessarily mean that that purchaser uses it, like especially in a way that's going to relate back to NASCAR.
So if NASCAR sells the rights to use its intellectual property, maybe just the name, maybe a logo, how is it supposed to know all the products it would be used on unless it was clearly defined in a contract? And therefore, how would it even be able to determine the proportionality for Ohio of something that was maybe a nationwide flat fee agreement to use its property? It has to be the population. So you're just saying based on Ohio population compared to the rest of the United States?
Either it could keep track of all that information, or it could use population as a rough estimate, the way that we have here. In terms of just figuring out where the proportionality ends up, I don't see any problem. And the Multi-State Tax Commission, for instance, clearly authorizes using population. We wouldn't have had a problem sizing those by population. So in terms of attributing where the intellectual property is used, I think the population is a perfectly fair metric.
I mean, because like if I buy a photo from Shutterstock, they don't know how many times I'm going to use it unless they put a limit on it, or where I'm going to use it and where it's going to show up. It doesn't seem like it's that much different from what's happening here. And where is the notice in the statute that they have to do all this record keeping?
So 2 points, Your Honor. The first is, as we've said, population will be a fair metric. The second is that it sounds like these hypotheticals are going to the first sentence of Division F, which only applies when NASCAR's receipts are based on the amount of use. If NASCAR's receipts are based on the amount of use, then obviously it's going to have to do some of that tracking anyways in order to calculate how much it's going to get paid. This is an entirely different situation where it's based on the receipts are based on the right to use. Fox purchased the right to use upfront. It's the money that NASCAR received didn't have anything to do with where Fox ultimately used those rights. What matters is that it purchased the right to use in Ohio, and under the statute, we can tax the value that the right, including the right to use in that transaction, added to the transaction.
And the metric that is being used is the number of televisions in Ohio? Is that what you're telling me?
So for this audit period, the commissioner used the number of households with televisions in Ohio.
Well, counsel, wait a minute. Is that the presumption that everybody that has a household with television watches NASCAR? Because, you know, if I was polled on that, they wouldn't be including my household. So I'm wondering, how does that become a legitimate, you know, even a legitimate starting point?
So the starting point is the text of the statute, which indicate what the CAT says that when an entity fails to file a return, the commissioner can rely on any information in his possession. Here, the commissioner could have used population. He used households with televisions, which is a slightly more precise way to calculate the proportion than population, and that only meant a small increase in the percentage. If the court finds that that particular approach was not reasonable, then it can remand for the board to apply the population metrics, which are just like 0.5% lower than that. But I don't think that we can fault the commissioner for trying to get a closer gauge as to what NASCAR's viewership audience was by using households televisions versus the population metrics, which I think we all believe would be reasonable.
Thank you. Thank you. You've used your time. Okay. Mr. Hayden, you've used your time as well. You may take 3 minutes.
Thank you, Your Honor. I'd just like to point out a few things in going through my colleague talked about. It seems to want to argue policy and looking at clues as opposed to rather than the statute. And I think we need to look back at the plain ordinary meaning of the statute. And I'll just give you an example. Under the administrative reg for services, which is what the commissioner originally wanted to tax us under broadcast services, there's 57 examples with different standards on how to apply the CAT. So trying to say that there's some market-based, broad-based standard that applies, it's just not correct. You've got to look at each individual statute and interpret that statute and apply that statute in accordance with its plain meaning. I think it's interesting, and I think everyone struggles with use, but I think that the second category here, or the second test, which my colleague has admitted that is the second test, and that's what is applicable, is are the receipts based on? NASCAR didn't perform some sham transaction or subterfuge to get around this. These are contracts that have been in place since 2005 and before. These are long-term contracts that are repeated. They couldn't have anticipated the Ohio CAT law and how that was going to apply. These are real economic transactions. And what the commissioner has proposed, I just want to say, the information in this case was population information that was taken from infoplease.com, which was a quiz show website, and then wanted to take unverified information from another audit that they first said was Nielsen ratings. And only on deposition did we learn that those weren't ratings at all. They were just a number of cable TV houses or households with cable TVs, not whether they were ever turned on or even tuned into NASCAR, as the Chief Justice points out. So I think those are important. This is where that slippery slope comes in, that if we allow this type of ad hoc type of taxation to take place, think about taxpayers that don't have the resources of NASCAR to defend on these cases. I mean, this could be a watershed case that anything that ends up on a screen or a shelf in Ohio is somehow taxed now to the content creator. I mean, that's not only against the statute, but it's unconstitutional. I think that, you know, in terms of the CarStar case, I just want to go back to that real quickly. It's clear in that statute that the commissioner can't change his final determination. We're not talking about key services where they're bringing up additional arguments. We have no problem with that. We all know that that's the way that the BTA level applies. This is a case where they completely changed their entire statutory method, the statutory section that they applied upon, changed it from services to intellectual property receipts at the appellate level before the Board of Tax Appeals. And the Board of Tax Appeals' own precedent says, we can't do what you can't do, Commissioner. We can't look at a broad statute that says that the Board of Tax Appeals can remand. Matter of fact, that CarStar case comes out of where the commissioner was testing the limits and trying to increase an assessment at the time of the Board of Tax Appeals, and the Board of Tax Appeals said, no, time out, you can't do that. Well, why should they be able to change their entire basis at that point? And I think on the constitutional case, I'll just mention a couple of cases. Greenscape says that you don't have to have, everything pled out for a constitutional claim. You claim Commerce Clause, and that's enough, because we don't want to take a hyper-technical reading. That's this court's own holding. And then in Corrigan, there needs to be not only nexus over NASCAR or the taxpayer, there has to be nexus over the transactions at issue. NASCAR did all of these activities outside of Ohio. Only its licensees or their, in turn, sub-licensees brought the property into Ohio. And with that, I'll rest.
Thank you, Mr. Hayden. Thank you, gentlemen. We will take your matter under advisement, and you'll be notified of our decision.
Thank you.
Our last case this morning is 2021-1233 Medina County Bar Association versus Russell Anthony Bazzelli for the respondent. Mr. Bazzelli. You'll have to unmute yourself, Mr.
Thank you. I'm sorry. Thank you, Your Honor. Again, good morning, Chief Justice, and to members of the court. My name is Russell Anthony Bazzelli. I would like to reserve 7 minutes of time in the argument, and good morning to Ms. Walker as well. May I proceed? Thank you. As it relates to the entire case, before I begin, I'd first like to say, extend my sincere apologies and sorrow for anyone who has been hurt, including Ms. Sheridan, Ms. Foster, and Ms. Tremonti, by my actions. Also extending that to members of my family and to my wife. Having said that, at the same time, I'd like to address issues which I feel during this case have not been addressed, because I will be genuine, not disingenuous, by taking one approach and one approach only. And that is, I have steadfastly throughout this process attempted to maintain my position as far as what I have admitted and what I have done. More specifically, I had stipulated to the 1.7 violation as it related to the Foster case. At hearing, and I do not know why earlier as to Sheridan, I admitted to the 1.1, 1.3, and 1.4 violations. With that, at the same time, I have to be clear that in my position, I stand separate and apart from a second brief that was filed on July 27th by my former counsel, Mr. James, because in that he made certain representations on his brief at page 13 at numbers 1 through 5 as to what he placed as what he perceived as admitted violations without any discussion with me whatsoever. I am unable to have a discussion with respect to that as far as the stipulation at 1, which is a 1.7. And I've already said that I've stipulated to that. As it relates to the motion to the remand that has been filed, I do have to state that with the amount of time given, and I thank the court for that, that findings were made. And the findings that were made by the panel, specifically as to count 1, deal with findings that are not in the record. And I demonstrated by the motion to remand in this case, as far as the claim violations for 1.4, 3.3, 5.3, that there are publications that are publicly available that show that there was no fraud committed upon a tribunal. Number 1, there has been talk about an answer. It was a reply. It was a reply in stanter, and when it was filed, and as the court's order shows, there was no forgery or unauthorized use of name. Instead, it was filed in the fashion of an instanter so that Ms. Foster would have the opportunity to either accept that reply and stanter or not. And the court's entry and order that was issued by Judge Sarah Lloyd provides exactly that set of facts. So with that, I would have to respectfully take issues with the panel's findings, because the panel's findings in this regard directly contradict what the tribunal has said and directly contradict the email that was sent to Ms. Foster dated January 2nd. I provided a copy of that to the panel in the motion. The relator counsel has stated that Ms. Foster didn't know anything of what was going on in federal court until January the 11th. I just bring that to the court's attention because with a remand, I'm not asking you to believe me. I'm not asking you to not believe me. I'm asking the database that's available, or the databases that I have said since day one. Look at my emails, look at the transactions, look at the filings. Those don't lie. They provide exactly what I've been maintaining as far as the Northern District Court as it relates to those allegations in count one. Finally, as it relates to the count one, I shift to the second motion, which is the request for a second request for remand on the bases of due process. In the panel's findings in count one, as I understand them, they have made the finding that I have committed a crime. It is very quickly, to save time, 2903.11, menacing, is the claim of the hearing officer, the judge who wrote the opinion. Unfortunately, if I understand the rules and if I understand the attendant case law and the decisions of this court, in order to have such a finding, there must be a conviction. If not, then there would be an interim suspension until such time as anyone in my position would have their day in court. I have not been provided all of the discovery. I have asked for it repeatedly. There's been spoliated items that have been provided. We've objected. It's a matter of record, and we still don't have these. Putting those items to the side, I would ask, in addition for the remand on those issues in count one and count two, then as it relates to count three with respect to Mrs. Tremonti, that the remand be had for the same reason. I have been accused of filling hours, puffing hours, yet I provided with the final detailed billing that I was able to assemble by going through emails that had become unlocked, matter of record in the computer's database, again, the metadata, and was able to recreate the bill that had been hacked out of my computer. I provided emails that were sent to Mrs. Tremonti that indeed corroborate these hours. Where those emails are, they've been provided to bar counsel. They've been provided to my counsel in Columbus, Mr. James. I do not know. But I would ask the court not to believe me or disbelieve, but again, remand for purposes of looking at the database that shows that the activities that I claim in my billing for Ms. Tremonti indeed are not only real, but are corroborated and in conjunction with my calendar. There are numerous visits and conferences that took place, phone calls. All these have been documented. I appreciate the tough job that the panel had in trying to go through and sift through the billings when someone admits they have had their computer hacked. I told everyone that this is not the true representation. I am trying to put this together for the panel when this case first started. I have been working diligently on this issue of billing until such time as I completed the bill and I gave it to counsel in Columbus, Attorney James. Why it was presented or not presented, I don't know. But I would ask the court to consider that, and I believe that I'm out of time at this point.
Mr. Bozzelli, I have a question on count one.
Yes, Your Honor.
On count one.
Yes.
I understand your argument about the menacing, but I need to know, right before that in the report and recommendation, there's a quotation of you, allegedly of you speaking, that Ms. Foster taped about you claiming to have killed a human being.
Oh, Yes,
Is
please.
that an accurate recitation of what the audio shows?
That's what it does say that, yes.
And was that you?
That is me, yes.
Okay. And was Miss Foster a client of yours at the time? Later on in paragraph 23, it says at the time you were representing her in Barberton Municipal Court on post-conviction and Section 1983 action in the U.S. District Court. Were you doing that at the time you made that statement?
To the best of my knowledge, the answer is no. And the reason is the last representation that would have taken place. Should I go further, Your Honor, or did I answer?
No, I just want to, yeah. So you didn't represent her at the time you made that statement to her?
At that point in time, that's correct. My last representation of her would have been on October the 12th, and that would have been of 2018 as it relates to the divorce case. All that remained at that point in time was the Northern District case, which I had already informed her that I would be eventually withdrawing from.
Okay, well, this one says in paragraph 22 that the conversation took place on September 23, which would have been about a month before you stopped representing her.
No, excuse me. To the best of my knowledge, Your Honor, that is Justice Fisher, that is incorrect.
Okay, thank you.
Yes. And with that, I believe I am out of time unless there are any other questions.
Ms. Walker.
Thank you. Good morning. May it please this court, I am Patricia A. Walker, Bar Counsel of the Medina County Certified Grievance Committee. I represent relator in this matter with Patricia Lowry, who will not be presenting this morning. The key words are remorse, responsibility, and respect, none of which have been shown by Mr. Bazzelli. Mr. Bazzelli was found by the Board of Professional Conduct to have violated 18 rules of professional conduct. The board found 6 aggravating factors: dishonesty or selfish motive, pattern of misconduct and multiple offenses, submission of false evidence, false statements, other deceptive practices during the disciplinary process, refusal to acknowledge wrongful conduct, vulnerability of and resulting harm to victims of misconduct, and failure to make restitution. There was only one mitigating factor, that he had no prior discipline.
Could you remind me of the made-up evidence you just referenced?
Yes, the made-up evidence was the 2 billing, the Exhibit O and Q that were in the Tremonti matter. And also the Exhibit M, which was the decree that stated Ottawa County when Mr. Bazzelli, the clients were in either Summit County or Medina County. And it also had a date of hearing of December 1st, 2018. But at the time Mr. Bazzelli was fired on October of 2018, nothing was pending in court, and there was no hearing date of December 1st, 2018.
So is it Medina County's contention that that statement was made while he was still representing Ms. Foster, the one I referenced earlier?
Yes, as the record will show, the documents that Mr. Bazzelli filed yesterday show that he did not withdraw from the federal case until January 2nd, 2019. And the threat occurred in September of 2018.
And does Medina County Bar support the panel recommendation of 2 years, 6 months stayed, or the board recommendation of 2 years?
We believe that the 2 years is appropriate. We had asked for an indefinite suspension, but we agree with the 2 year suspension. Mr. Bazzelli has not shown remorse until today. There have been no statements about apology prior to the day. Further, he has never said anything about how he wanted to change his legal practice. He hasn't shown responsibility. The hearing panel found that Mr. Bazzelli was evasive, vague, accusatory, and his allegations unsupported by any credible evidence. And we find his statements here today also problematic. Mr. Bazzelli blamed the grievance and others. He blamed his wife's illness, but moved in with his lover when his wife was in rehab. He filed a civil protection proceeding for his wife to get back at his former lover. In his objections, Mr. Bizzelli contends that a long suspension would hurt his wife, but the board found that Ms. Bizzelli was able to return to work in 2019 and continued to be able to be at work. He does not take responsibility for his actions. In his answer in the complaint, he admitted no violations. On the second day of hearing, he admitted the Rule 3.3A1 violation, which yes.
Can I just interrupt you for a minute? Is Ms. Bizzelli still able to work? Do you know?
All I know is as of July 2021, she was able to work.
Do you know if she was working?
She was not. She was working for Mr. Bizzelli if she was working.
Okay, thank you.
On the second day of the hearing, Mr. Bizzelli admitted that he violated Rule 3.3A1. Yesterday, he took it back. In the objections, he admitted that he violated Rules 1.4A2 and 5.3A, and yesterday he took it back. The court should be aware that there's a stipulation in this matter that clearly addresses his issue on remand. He says that he didn't tell the federal court anything wrong. However, stipulation 14, which Mr. Bizzelli said he agreed with, says after Attorney Bizzelli withdrew from the 1983 action in federal court and without any consultation with Ms. Foster, Attorney Anthony Bizzelli filed an answer to a counterclaim in Stanter on behalf of Ms. Foster, signed Ms. Foster's name to the document, and filed it in the same 1983 federal court lawsuit. This action was taken without the knowledge or consent of Ms. Foster. That is a stipulation in this case. The document that Mr. Bizzelli points to, the order of the court, was in front of the hearing panel. It was Respondent's Exhibit D4. The panel was well aware of it. And in that document, the court asks whether or not the reply in Stanter really was Ms. Foster's or not. It doesn't sound like the court knew exactly what was happening, and that is the reason for the 3.3A1 violation. There have been no constitutional violations here and no need for remand. In his filing, Mr. Bizzelli states that Magistrate Rizzavi was listening to the hearing and then testified. Magistrate Rizzavi never testified. Therefore, there could not be a due process issue. Mr. Bizzelli was not convicted of a crime. He was found to have done something that was equivalent to a crime, and that was threatening to kill his client. Further, as far as discovery, Mr. Bizzelli never filed any requests for discovery, and any informal requests for discovery were answered. There is no record in this case that discovery was not given to Mr. Bizzelli's attorneys. As far as respect, Mr. Bizzelli has not shown respect to the court, the disciplinary system, or his clients. We believe that since there has been no remorse, no responsibility, and no respect, that the board's recommendation of a 2 full-year suspension, petition for reinstatement necessary, and 6 hours of CLE involving the issues of sexual harassment and employee management, along with the normal CLE requirements, is $7,869 restitution on Ms. Tremonte's claim, and that Mr. Bizzelli pay the costs. Thank you.
Counsel, you recommend, or you agree with a 2-year suspension, okay? Yet I just heard you say that he has to petition to be readmitted. Isn't that the process for an indefinite suspension?
That would be my understanding. However, the board found that he needed to petition for reinstatement. So
Okay,
I'm not sure how we resolve that issue.
Okay, and I'm presuming that is then to show that the contingencies are met. In other words, restitution, etc.
That would be my understanding.
Okay. All right. Anything further, Ms. Walker?
No, thank you very much.
Thank you. Mr. Bozzelli, you have saved over 5 minutes.
Thank you, Your Honor. First, very quickly, as it relates to the separation agreement that states Ottawa County and the date, we were shooting for December of 2018 because that's when the change in law would have taken place with respect to whether or not spousal support could be deducted. That was strategy. Ottawa County is listed because at that time, the statement was made and the request was from Mrs. Tremonti. She did not want to do this anywhere in the area, and that there would have been an establishment of residence by that time as it relates to a dissolution. Now, good, bad, or indifferent, you can inquire of her in that regard, but that's what took place, and that's not a fake document. But again, please go to the database, which shows in my computer what did and didn't happen. Don't listen to the words that I use or don't use. That will show what did and did not take place. And that goes to the billing as with Tremonti as well. As it relates to the issues of mitigation, Your Honor, with respect to the statements that have been made, I am not clear as to what my wife's work or ability to work is playing into this other than what has truthfully been made in the way of the statement as far as hardship. My wife continues presently to not be able to work. She's had, unfortunately, yet another surgery. She is a fighter and she's on her mend. Now, having said that, this is about what I did. I own responsibility for my actions or inactions. As it relates to mitigation, I'd ask the court to consider, first of all, as to Ms. Sheridan. When I was no longer on the case, that was not the end of it. Once I found out who appellate counsel was, an inquiry can be made. I worked directly with him to ensure that the outline that I created at day one of that case was utilized. Specifically, that this was an insufficiency case because of the lack of a record, because of the problems they had with the tape recording system. I also had 2 and 3 phone calls after that with Attorney Wesley Johnson. Whether or not that is a matter of discussion or belief, he is available for that purpose. The good news is, unfortunately, and my apologies again to Mrs. Sheridan, is that the arguments that I created resulted in a reversal on the basis of insufficient evidence in the Court of Appeals on her case. I don't show contrition and remorse just because of my makeup by saying how sorry I am when I am sorry, but I have to prove it by my actions. And hopefully my actions in assisting counsel will show that I back up my words and I own what I did. In addition to that, there have been no other prior disciplinary actions. I have cooperated through the disciplinary process, providing documents 2, 3, and 4 times, making sure that everything was provided that was requested. As far as restitution, we are still waiting on a ruling in the Medina County Court of Common Pleas where the individual who stole monies in excess of $15,000 from us, which have not been repaid, even though the hearing officer, all due respect to Judge Koss, has stated. And instead, there's a hearing on restitution on what that amount will be. Those were the monies, our savings, that would have gone to pay Ms. Tremonti. She would have been paid by now had those monies still been available. As it relates to anything else with respect to mitigation, I would just respectfully disagree with the statements that have been made, only that I have always been very upfront and clear as it relates to our marital counseling, individual counseling, the letters that I provided, that I do volunteer work pro bono. I was awarded volunteer legal services project attorney for 2020, only to have that award taken away in 2021 by the Medina County Bar at their request, the Relator Council. I don't say that because I want awards for the things that I do. I'm supposed to be detached after I do something to be of service to everybody else. But I have to mention them now so that you know that I do not focus on selfish motives. I try to help other people as much as I can, and including pro bono cases. As far as other activities are concerned, in pro bono, I have also done that through the juvenile court in Summit County. I have done that with senior citizens through volunteer legal services and legal aid. And I also have worked on the Wadsworth Drug Free Community Coalition, being their counsel. And from a personal standpoint, as I said, individual counseling, I attend NAR-NON meetings at least 2, if not 3 per week. I have a sponsor, and I continue in my personal counseling for my PTSD and GAD, which I have had since my victimization as a child. So with all of those things together, I want the court to know I did contact OLAP. I'm not using that as for any excuse, just so that the court is aware that I have disclosed these things, and if they have any questions, fine, please, I will do my best to answer them. Thank you very much.
Thank you, counsel. We will take the matter under advisement and you'll be notified of our decision. Marshall, will you please adjourn court?
Hear ye, hear ye, hear ye. This open session of the Honorable Supreme Court of Ohio now stands adjourned.